Hi, and welcome to Two CPAs and the Mic, the podcast where we talk tax, finance, and all things related to business. Whether you're a business owner, working professional, or someone who wants to start a career in accounting, this is the podcast for you. Hosted by CCK Strategies partners Jeff Frable and Sarah Mays, we dive into relevant business and tax matters with working professionals to make these topics less intimidating, relatable, and dare we say fun? Let's get down to business.
Welcome to this week's episode of Two CPAs and the Mic. We are covering relevant business and tax topics by applying straight talk, practical information, and without all the jargon and stuffiness that's normally associated with our profession as CPAs. I am Jeff Frable, a partner with CCK Strategies in Tulsa, Oklahoma, and we are so thankful and excited that you're joining us wherever you are today. Kristie Porter, what's up?
Hey, Jeff. I almost said, hey, Frable, what's up? Because we have a missing component.
We do have a missing component. Sarah Mays is not with us. She's not with us today.
No, she's living.
She's living. We'll get to that in a minute. But just in case you're wondering what today's episode is about, we are going to be talking about estate planning. And I know this is it's a hot topic. It's a burdensome topic for many people. And like always, our goal is to go through this topic today in a way that is not in the weeds, but high level, understandable. And we have a perfect guest for that. He is an attorney, but he speaks real speak. He's a real person, and we're going to have a great time with him. But again, we want to keep this at a very high level. And Kristie, if you remember last season, we did have a episode on estate planning.
Yep, we did.
But we went more so from the tax perspective. And this time we're going from a legal perspective. So if you are a business owner listening to us today, strapping on your shoes, go for a run, go for a walk, whatever you're doing, I think you definitely want to stay on here because we're going to talk about things that are very important to the continuity of a business and how to protect your assets, how to protect your family. And if you're just a business professional, you definitely want to stay on as well because we're going to talk about ways to protect your family and your assets as well. We're going to talk about what's important, what's not important, what people need to worry about and what they don't need to worry about, and what's the best way to take care of your family. But before we get to that, it's time for friendly banter. So life updates, KP, what's going on in your life?
Well, I got to tell you, I'm just glad it's June, you guys.
It's hot.
It's
starting
June.
to get hot.
There's something about the beginning of June that just gave me new energy. I found myself writing emails that said, hey, happy June, everyone. Kind of nerdy, kind of summary.
Yeah.
But I don't know what it is. I think it's just maybe a turning point in the year, but I'm grateful that it's June.
Well, it is June 1. That means we're 2 months away from August 1, which means it's the beginning of the September 15th tax season. So,
yeah, let's go there, Jeff.
Yeah, let's go there right away. But no, it is June. It's getting warm in Tulsa, Oklahoma. Last week, I was in Pennsylvania. Remember last episode, we were all over the country pretty much.
We were.
And so it was nice in Pennsylvania, back in Tulsa now. You know, the most exciting thing this week, we had a speed trap by our office.
Yeah.
So did you know about this, Scott? You're just down the road. Did you know about this speed trap?
No, I saw it in action.
But
I didn't know it was coming.
Yeah. So there's a hill by our office, and there have been two police motorcycle cops
hidden.
not patrolling, sitting there
hidden
at the bottom of the hill or midway through the hill all week. And I think 2 days in, they had given 150 tickets and they've been there another day and they're there again this morning.
It's been a running joke in our office because we can hear them take off.
Yes.
And their motorcycles, they have that big
roar.
Yep. And even it gets a little dramatic. They start playing their sirens, or that's probably not the proper terminology, is playing their sirens.
I'm pretty sure that's what they call it. Hey, let's play our sirens.
So the joke on our end of the floor, our end of the office, is because I have a bird's eye view of it. And you hear the roar.
Because you have such a cool office.
I do have a corner office.
Let's just go there. Okay.
You hear the roar, then you try to decide which car they're going after.
Yeah.
And then you see the cop. And I'm telling you what, they go fast.
They do go fast.
In a short distance. And sometimes they weave through traffic. And the other day it was raining. And I'm just like going, how is this not going to hurt someone? But anyway, City of Tulsa is getting their quota this week on the southbound on Yale Avenue. But that's been the most exciting thing. maybe the second most exciting thing is you mentioned Sarah's not here.
Yeah.
You want to mention why she's not here?
Yeah, Sarah is taking a certification course this week, which is just going to give her some more letters behind her name.
CVA,
yeah. Valuation, which is, I'm going to tell you, it is hard. And Sarah is high intellect.
She's ready to go.
She can really take it on. I spoke to her earlier in the week and just, how's it going? She's like, man. So I can't wait to hear.
Yeah.
She's going to earn it. Let's just say that. The work she's putting in this week, she's earning it.
Next episode, we may have a little bit of celebration.
let's do it. Let's do it.
One other update. We have new chairs in the podcast.
If our sound
studio
sounds new and improved, it's all because of the chairs. Yeah.
It's amazing how much effort you place into recording when you are lower than the microphone.
Yes.
So
we considered child booster seats and
I was sitting on reams of paper.
I wasn't going to share that. I wasn't.
Actually, I'm sharing, this is full transparency. I cannot touch the floor in my chair right now. My legs are dangling.
Oh, I didn't know we were going to be this honest on this podcast.
Sorry, Scott. We're gonna dial it back a little bit.
Jeff is a small man. He's a short guy. So I know everyone's kind of wonders, what does Jeff look like? We need to get real pictures on the website.
Okay, let's do it. I really like what we have out there now because if anyone wants to see it, Jeff has a new watch face on his graphics. So it's all about the details.
All right. Well, that's enough for friendly banter today.
Thank you for going with us.
The real topic, the real purpose we're getting together today. Again, we're talking about estate planning. We have the one and only premier estate planning attorney in now, I would say, not just Tulsa, but Oklahoma, Scott Helton. Scott is the owner of the Helton Law Firm in Tulsa and in Oklahoma City. They offer big firm experience, but small firm values. So when you go to see Scott, you will see his teammates all in action. Scott and I have known each other years and years, and this is all full. We were talking about this earlier. This is all full circle because Clarence is over here in the corner doing sound, but the three of us have known each other for decades now.
I love it.
And so we're really pleased to have you today, Scott. I know you're going to be excellent with just talking about these issues in real terminology, plain English, not getting too deep and highly technical. You're just that kind of guy. So Scott, tell our listeners who you are. Give us a little bit of your background, your experience. Why should they be listening to you? And maybe most importantly, what is your why when it comes to estate planning? Because I know it's very special to you.
Well, thank you, Jeff, for that introduction.
Yeah.
I feel like if I'm ever down, I just need to come to a podcast.
That's right.
You're always welcome.
Boost it up a little.
You have a seat.
No, thank you for that. And thanks for the opportunity. I love estate planning. Our firm does a little bit of everything. We do a lot of business services, a lot of real estate, probate, commercial litigation, but my heart is in the estate planning, probate world, helping people pre and post death, either plan to get things organized or maybe when they haven't, helping the family clean things up after the fact. But our firm, we have about 18 attorneys, and we have several that work in the estate planning world, several that help with guardianships and probate. And then litigation, we do a lot of real estate work and like mergers and acquisitions, a lot of commercial work. But, the one area that I feel like is the easiest just to help people is in the estate planning world. My why, I would say probably is a couple of things. One, I love problem solving. I love helping people that don't know what they need, that don't know what their options are, and kind of connecting the dots for them. And then really just the relationship side of it. I'm a people person, and I want people to, to feel good when they walk out of the office because we've helped them solve a problem or we've helped them, better understand their options and things like that.
So when we get into the topic of estate planning and talking about this process, talk a little bit about what it really is, what it isn't. And the thing that I find most interesting about what you just spoke about was you mentioned it's one of the easiest things to do, but I think a lot of people see it as a burden. And is that because they just don't know, they just don't understand, or because of the reason that we're talking about passing, the inevitable event that happens at the end of our life? Is that just people don't want to talk about that? Or so What is it? What is it not? And why is it such a burden?
Yeah. So it's really, estate planning is two things. It is incapacity planning. It's planning for still being alive, but losing your ability to make decisions for yourself because of developing dementia or in an accident where you're in a coma or you can't make decisions for yourself. How do you make that process of handling things, for a loved one that is alive, but not legally able to handle things, with power of attorneys and things like that, trying to avoid guardianship and the court involvement. And that one is really easy to solve. I mean, power of attorneys are pretty straightforward documents, and it just fills that gap where instead of having to go to court and get a court to order things to happen, you can just handle it with the person that you choose to make decisions for yourself. The other part of it is the death planning, and it's how do you get your stuff where you want it to go? And there's a lot, obviously, of dynamics with that, of family dynamics and kids with different situations, blended families, business interest. And there's a lot of options that with good planning, I mean, you can have a lot of control over where it goes, and your family better than even, your kids do and what's going to be best for them. And so with some good planning, you can lay that out and just make it a really clean process. The hurdles really are everybody knows that they need it. Everybody knows whether you want to admit it or not, death and taxes are coming. So it's usually not an issue of knowing that you need it. And really, it's not as much of an issue of understanding your options. I mean, there are a lot of options and there's some education that goes on. It's really just a matter of human nature and getting around to it and acknowledging that, yes, I need to take care of this. And what we find is that a lot of people will say, yeah, for sure, I need that, but I'm going to get to that next week. And they don't ever do it. And so just kind of overcoming those hurdles just from human nature is the biggest part of estate planning, really.
I know we'll get into this a little bit more, but I can imagine that at some point in time, you become a little bit of a counselor through some of these discussions. You get into some very complex situations with families. And I wonder if there's an element there as well where a husband and a wife have a complex situation and maybe they just don't want to deal with those issues or have to come to those conclusions about, well, we have a blended family and we're just not sure where things go, but now we have to make these decisions. You run into that a lot as well?
All the time, every day. I mean, it's, blended families, but even just not blended families, but trying to decide, we've got a couple of minor kids and he wants his parents to be the guardians if mom and dad are gone, and maybe she wants her sister. And they've never really had deep conversations about it, but they put it off because they just don't want to get into an argument.
Right.
And that's something that we can deal with tomorrow, and tomorrow doesn't always come. And so there's a lot of dynamics to that can create sort of unspoken barriers to getting it done that typically once we can sit down with them, we can sort of take some of those dynamics out and ease them through those conversations that in most cases, it ends up not being that big of an issue, but it's one that's just easy to push off.
And this is just, right now, we're just talking about individuals and families. It's that on steroids when you probably get talking to business owners and you start talking about succession planning and things of that nature. Talk about some conversations that need to come up about how is a business going to be run? How's it going to be operated? Who's going to take over? You have that same type of dynamic, I would imagine. Is that right?
Yeah, for sure. I mean, that's a little bit different issue of sometimes business owners, they're busy. They're trying to keep everything moving forward. They've got 20 deadlines to hit and a lot of different things they have to take care of over the next 3 days. And planning for the future, sitting down for an hour doesn't fit into that schedule. And so I know that probably never happens on your end.
We have all the time in the world.
But it's just another human nature thing that I get. I'm a business owner, and when you have a lot of fires to put out, the ones that are not immediately on fire typically get pushed out. And then there's the aspects of it of really having to make some decisions of, am I going to have some succession planning with someone internally, or maybe there's a one of your 3 children have been involved in the business and the others are not. You don't really know how do you make that fair. And so again, it's easy just to push that off.
Yeah. So let's start getting into some of the details now. And we're probably going to jump back and forth between business owners and individuals and the different things that they experience and the different things to consider. But let's talk about one myth that's probably out there. And if I say that estate planning is just for millionaires, Scott, how would you respond to that?
That's a pretty common myth. I mean, it's a pretty widespread thought, especially when you're talking about trust. People hear trust fund or
trust fund,
foundations, and it sounds like something for wealthy people.
Can we define it?
Yeah, sure.
Yeah. So when you say trust, what's the definition? What is it?
So a trust it's its own separate legal entity. It's its own separate thing that can own assets while you're alive or even after you pass away. That it's a conduit to transfer your things outside of probate, outside of court supervision. That gives you a lot of control over who's in charge of carrying it out, exactly what they do, when they do it. And there's a lot of flexibility in setting up this entity to be in control of how your things pass. And none of that has anything to do with the value or the amount of assets that you have in the trust. It's a mechanism for transferring whatever you have, whatever that is. And of course, if you have $20 million, there's a lot of benefits things that you can do to simplify some of that. But even if you have, $1 million or $500,000 or a house and 3 or 4 investment accounts, it's a good process and a good mechanism to make that transfer of those to who you want it to go to, much smoother.
So let's just kind of set a firm foundation and get very, very simple here. I'm an individual. I own a house. I have some investment accounts. I don't want to put numbers on it because I don't want people to get tight, because this is about people, not necessarily money.
Right.
About assets. So I'm an individual. I have a house, have some investment accounts.
Do you have kids?
I have kids.
Are they minors?
Yes and no.
Okay.
They're minors and they're not minors.
Okay.
I'm married and something I die unexpectedly. My spouse and I die unexpectedly. What happens to my house? What happens to my kids if I've done nothing at all?
Yeah. This is high level because it can get complicated really quick.
I know it's not black and white.
Sure.
But one really common misunderstanding is most people think, if I don't have any plan, surely everything goes to my spouse. I mean, it's what most people I think would want and what people would expect, which is not true in Oklahoma at all.
Okay, so let's say I'm that individual and my spouse doesn't die. So just I die and those are my assets. Go on. You said it doesn't necessarily.
Yeah, so there's certain things, like most people's property are jointly owned with their spouse, and that is going to transfer with a little bit of paperwork. There's no probate involved in that. Joint checking accounts and things are going to go to the spouse. But if you have assets that are not like that, you have a house property that's just in your name, or you have an IRA that you don't have beneficiaries listed on. Under Oklahoma law, if you have an asset that's going to pass through that probate process, it actually is split between your spouse and your children.
Okay.
And there's different percentages depending on blended families and what the asset is. But not everything goes to the spouse. And that may not be a big deal with a family where everybody gets along really well. The kids say, no, Mom, you take it or whatever. But a lot of times it's not the case. And you can have some really serious issues with assets that Mom might need, but it's got to go to the kids.
Scott, you say probate. I've heard it a couple of times. Would you mind defining what's probate?
So a step back before answering that is there's a certain nature of your assets that certain assets you can designate pay on death beneficiaries or joint owners. So if you have a checking account with a husband and wife on there, they both own it. If one dies, the other's going to continue to own it. When the first one passes, nothing really changes. Same way with a lot of real estate, depending on how it's titled. Or you can list pay on death beneficiaries for your IRAs and your 401ks, and that pay on death beneficiary is who the bank is going to pay that to. That's all done privately. It's contractual between the financial institution and their client. They're obligated to pay it to whoever you tell them to. So those are going to transfer. But if you have assets in a deceased person's name, the only way with caveats, that we won't get into. But in most cases, the only way to transfer those assets to whoever it's supposed to go through is a court process called probate. And it's the judge oversees if it's a lightning fast probate where everything goes perfectly, you're looking at 10 or 11 months of process.
Wow.
$4,000 to $6,000 in publication fees and filing fees and attorney fees, just for the judge to look at it. If, is there a will? Is it valid? Who are the creditors? Have they all been paid? Have the correct people received their inheritance? It's good in that there's oversight to make sure that things are handled the way that they're supposed to. But it's a really long and cumbersome process that is really great for probate attorneys like us, but not usually for families. And so if you can avoid that process, it's so much easier for your family. And one piece of that a lot of people don't think about is you may have a family that gets along pretty well. There's always been, some things kind of a little under the
Families
radar.
Are families.
Yeah.
Some friction.
It's tough. Yeah.
Everyone's kind of kept it together for mom and dad, but then once mom and dad are gone, with probate, the very first thing that happens is there's a court date set where everybody gets notice. If you have any issues at all, here's the date and the courtroom to show up at. And a lot of times what we find is that tees up conflict that would not be there otherwise. It's, people show up, there's tension, they don't quite know what's going to happen. And it sometimes can create a lot of conflict that just blows up the probate that 10 or 11 months turns into 24 months and a lot more fees. So anyway, the probate process is just transferring things and dealing with any issues like that. And so there's a lot of really good options for avoiding that, which is the part that people really need to engage in and try not to keep pushing off.
So in Jeff's example, Scott, if an individual is deceased and they have a trust in place, do they avoid probate?
Probably. Yeah. The good attorney answer is it depends on most things.
This is not advice.
Yeah. And I did want to take a step back. We probably should have mentioned at the very, very beginning that if you are listening to this, Scott is not providing advice in any way, shape, or form, just like we don't provide tax advice. You really do need to get engaged with a qualified attorney and that deals with your specific situation to get answers to your specific situation. So
what a great disclaimer.
There's our disclaimer.
Yeah, there it is. It goes really well with the probably.
If they turned off in the first 10 minutes, we're in trouble. But anyway, that's our disclaimer. So go ahead, Scott.
Yeah. So again, one step back before the trust is the idea of the will. So a lot of people think, well, I'm going to do a will and that's going to avoid probate. A will is better because it allows you to have some control over where your assets go versus just the default rules that the state has for you. But that will has to go through probate. And so it's great if you have a will, but you're still going through that court process. And that's where the trust comes into play as an alternative. And the idea with the trust is that since it is its own legal separate entity that can own assets, a husband and wife would take their assets, transfer them out of their name and transfer them into the trust name that they still control. It's revocable, which means they can amend it and they can make updates. They can put things in, they can take things out. They can amend the trust, cancel it if they want to, but they take it. And so technically the assets are in the name of the trust so that whenever one of those people pass away, the reason that they don't have to go to probate is because they don't own anything. There are no assets that are still in their name that would need to be approved by the court. And that trust continues to operate after the grantor, the settlor, after they pass away. The only thing that changes is you decide, okay, when I'm gone, here's who's in charge and here's what you do. It's all done privately. It's all done quickly. There's no approvals that are required. And it's really nice for business owners, especially for smaller business owners who maybe they are the business,
Right.
So they've got their HVAC company or they've got their, electrical company that maybe they have a couple of people that work for them, but they're out grinding every day, working hard. And there's value to that business. They have contracts, they have clients that other competitors or private equity or whoever would want to buy. But when dad's out of the picture, the value of that company, it goes off a cliff really quick. And If you have to wait on probate to get a court order allowing you to sell that business, well, there's no more business to sell. And so that business is owned in the trust, then the spouse, the wife, could go the very next day, theoretically, and sell it to a competitor and basically maximize the value that dad has put into that business for sometimes 20 or 30 years.
Sure.
So the bottom line is that if you want to avoid difficulty in transferring assets, estate planning is the way to do that. Because if you don't do it, there's processes and procedures that lengthen the amount of time for these things to transfer and just causes a lot of potential pain, confusion, frustration, and things of that nature. So if you want to do your best to control something after your passing, this is the way to do it.
That's right.
Okay. So the other thing I wanted, because we're kind of on this individual discussion, which I think is great. One thing I want to point out here, or point out to our listeners, you've used the term trust. And I don't want to get, again, into technical details here, but some of our listeners may be going back to the concept of a trust fund baby or something that's very extensive, complex, these types of things. There's differences in trust. There's a wide range on the spectrum. I think what you were talking about mostly was a revocable. People might hear it as a living trust, a revocable living trust, something of that nature versus irrevocable. So talk just a little bit, and without getting into all of the black and white details, because I know it's tough. What's the difference between revocable and an irrevocable trust?
Well, first of all, we need to differentiate between a revocable trust and a revocable trust. If you grew up in southwestern Oklahoma, out in rural areas like I did, it's a revocable trust. So you can revoke it.
Revoke it.
But if you want to sound more sophisticated, then you say it's a revocable trust.
Okay.
It's like finance and finance.
Yeah, exactly.
Depends on where you are in the country.
You just gotta know your audience, But it took me a long time.
And I bet you play to that audience.
Oh, that's funny.
It took a while for me to say it, the sophisticated way. But yeah, we are talking about a revocable trust, because you can revoke it, you can cancel it, and that is also amend it or restate it or make updates and changes to it. The other version is an irrevocable trust that you cannot change. And again, there's caveats to all of this, but generally speaking, an irrevocable trust is a trust that you set up. And once you sign it, once you put assets into it, you can't change it. You can't amend the language or the beneficiaries or how it's distributed. You can't take assets back out. You lose control over that. And there's certain times when that makes sense. We may talk about taxable estate planning in a minute. And there's things that are called ILITs, irrevocable life insurance trust, where you can buy insurance that you put into these trusts that are set aside that can pay estate taxes and things whenever you pass away. But because it's separate, that money no longer counts as your asset.
Right.
And then there's other liability avoidance. You can separate assets out. So if you're in a high risk profession or something, you can set up different trusts. And there's a place for that. For the other 99% of people, we're talking about the revocable trust that you can update as you go because you want to. As family dynamics change, as assets change, you want to be able to update that multiple times throughout a lifetime.
When I think about irrevocable, is that the proper way of pronouncing it?
Yeah.
Maybe.
Okay. All right. Well, for Oklahoma?
Yeah.
Okay. So when I think of that, I think of real estate. If you look at contracts, sometimes the purchaser is the trust and irrevocable trust in the name of ABC. So what's the advantage there? Because you can't change it?
Well, again, that might be a situation where they're doing that so that if they get sued down the road, then they no longer control it. So that's not an asset that the creditor can go after.
Got it.
And then again, there's other types of trust for that purpose. You really, when we're talking to clients, we really have to figure out what's your goal with some of these. And then there's different trusts that you can use to accomplish those goals.
And I think from our perspective on the tax side, the living trust is a living, breathing document. It is basically a shadow of yourself. And it has no separate identification number. It's your social security number. There's no separate reporting from a tax perspective or anything like that. It only comes into play once it's enacted through a passing of an individual. The irrevocable ones are more of what we would maybe refer to as a true estate planning. You mentioned the tax threshold. It's about 14, 15, 16 million per person that can pass to beneficiaries without any kind of taxation. Over that, there is an estate tax that's fairly hefty that you have to pay. And so one of the processes you would go through is to get it out of your estate, something that has some value, but you lose control of it. It is like you said, you're stipulating what you want to have done to it, where it's to be. And I guess there are ways to change those at some point in time, but it is not your asset anymore. And so that does get an identification number and has a separate reporting function every year while you're still alive. So the bottom line is you go from just owning a house all the way to millions and billions of dollars. There can be significant complexity to this. But if you're just like you referenced the 1%ers, which is most of us. I mean, that sounds really weird. Or, I'm sorry, 99% of us that don't have.
We know, Jeff.
Yeah,
we know.
We got you.
Everybody other than
Let's
me.
go. Yeah, we got you.
You don't need something that's real complex. It just is a matter of a way of controlling things the way you want before you pass. And that's kind of the bottom line, right, Scott?
Well, and we're really careful when we meet with clients to try not to get too complicated or bogged down with all of these more complicated trusts that serve purposes, but for most people are irrelevant.
Sure.
Because people come in and they've been on ChatGPT for 2 days and they got a long list of all these things, and we can easily say, okay, none of those are going to apply to your situation. Let's just get something in place for your basic estate planning, and that's
good.
And let's not put it off. Even for families that there is a place for some of those irrevocable trusts, we'll work on that, but it's 2 separate tracks, because let's just get your basic estate planning in place first.
Mm-hmm.
And then while we're working on the other one, at least we can know that assets are protected. They're going to transfer, more smoothly to your family if something happens.
I think that you bring something a lot like Sarah and Jeff talk about in tax. They have this term where they can be code heads, tax code. And I giggle at them and I'm always like, what does that mean? What are you talking about? For you sound like you can put the most complex and filter it down into the most basic common language that if I can understand it, anyone can understand it. So I feel like I'm tracking with you. And I think that would bring anyone who came to visit with you some assurance and not feeling like, what in the world is this guy talking about? Should I know more? Basically, what's the answer? Should they know more?
Well, they should. They should understand it. And they don't have to understand all of the law, which statute says whatever. But, our newer attorneys, we really train them hard to be able to don't just go in and just throw around big language. Hear the client's situation and then explain it in ways that they can understand. Because especially with trusts, they're great, but a lot of people have trust that they don't know what they say. They never really completely understood what they were getting in the first place. And all of our meetings, the first half of the meeting is just educational and just helping them understand what it is, because it'll work so much better if they know what they have.
The other thing that I like that you said, Scott, is I would call it a trust factor. I walk in because I've been on ChatGPT and I've got this whole list of stuff. There are some professionals out there that'll go, yeah, let's set all that up, even though they don't need it. You're going to sit there and go, I don't think you need all this. It's kind of like when new entrepreneurs come to us and they started a business and they go, well, I need to set up 4 different LLCs and it's like, no, you just need this.
Right.
Yeah, I would love to have those fees. That's great, but you don't need that. And so those are the kind of conversations that you're going to have with your clients.
Well, our whole culture for our firm is relationships with those clients. We don't want, one deal where we make a bunch of money. We want to have a relationship with them forever. We want to help their kids whenever they're out of the picture. We want to help with their business. And so we do want to earn their trust. Part of that is just helping them understand what their options are. But part of it is earning their trust with seeing that, we're having the conversation of financially, you've got money to spend, let's allocate it in the best avenues for your planning.
Right. So let's start wrapping up the conversation about individuals. And we've talked about wills. I think the wills get the most notoriety because they've been around the longest. I want to do this with my assets. You talked about the trust and the difference. What are some of the other biggies out there that really don't have much to do with the assets themselves? And I'm kind of referring to like medical directives, guardianship. What other things are out there that individuals need to be aware of that they should be utilizing that are important?
Sure. If you have minor children, you definitely want to nominate a guardian for who those children would go to if both mom and dad, parents are out of the picture. The way that works is if the two parents of a child pass away, the court has to be involved. The court is the only entity that can appoint a legal guardian to have custody, for those kids. But the nice thing is in Oklahoma, if the parents nominate a guardian, the judge still has to determine what's in the child's best interest, but they're usually going to rubber stamp whoever mom and dad picked. And so with some really pretty basic planning, the parents can nominate husband and wife, a couple, and then a backup. So that if they're out of the picture, they can pick who they think would be best to raise their kids. And so that's really pretty critical for a lot of families. The advance directive is an important one. Advance directive kind of goes along with the power of attorneys that deals with if you are incapacitated. And this most often comes into play with older clients that maybe are suffering from dementia or Alzheimer's or something like that, where they're reaching the end of life and some decisions need to be made about how long do you want to be on the machines and what types of machines do you want to be on? Do you want to receive artificial hydration and nutrition? Do you want to be on the ventilator? And those types of things are really important. And it's really, again, not so much for the individual, but it's really more for the family, because a lot of times the family's stuck with making life or death decisions that even though they may feel like this is what mom wanted, and maybe even what is probably best for mom, it's still a hard decision to make. And so with an advance directive, you can make that decision in advance, basically tell the doctors that if I'm in this situation, here's what I want you to do. And it takes a lot of that burden off of the family by doing those documents.
Yeah, it's good. It's a good point.
Scott, let's say I set up my trust 15 years ago and life has happened. Children are now adults. Parents who maybe were appointed guardian are aging. How simple is it for a family to go in and amend their trust?
Well, and you make a good point of trust are great. Trust fill a lot of gaps and they check a lot of boxes, but they're not perfect, because what can and often does go wrong with trust is that they're only as good as the assets that are in them. So again, human nature coming back, to unravel what we're trying to do. When we do a plan, we get all the vehicles in there, we get all the businesses and all the assets and property. They put it on the shelf and they're perfect. And then a year goes by and that starts to unravel because now dad bought his new F-150 and mom changed jobs and now there's a new 401k there, and you start to have loose ends, and you really have to be careful to make sure that as those types of things change, that you keep those updated current with the trust. And then also as family dynamics change. So maybe the kids aren't minors anymore. They don't need a guardian anymore. But now it's, they're 22 and we've got $2 million of life insurance and a couple $1 million of other assets. Do we want each of them to get $2 million put in their lap at 22 or 23 years old? And what you thought may be the case 5 or 6 years ago may not be anymore. Maybe one of them has special needs where they have a condition where they qualify for like state assistance or things like that, where if they get that money, now they're going to be disqualified for that. And so as dynamics change with the family, you can and really should update it regularly. And that's the nice thing, is that it's really pretty simple. Update it. You just have to keep that in mind.
Well, and that's one of those things that I would imagine comes with the consultation, and the setup is, how do I title these things? What names do I put on them so that they have that information going forward as the assets? It's not something that they need to come back in and see, especially with like the titling or getting the assets in the trust. They don't have to necessarily come back to the attorney every year to do that. It's just in the way they transfer or they title it and things of that nature, right?
Right. Okay. One thing that we do there's lots of really great estate planning attorneys in Tulsa. And I was emailing to one this morning that she sent some flowers over to our new Oklahoma City office. And I love a community where even with our competitors,
there's enough for everyone.
There is. And there's some really great professionals. But there is a difference between an estate planning attorney and everybody else. And so whoever you're working with, make sure that that's what they do. Yeah. But as things change, then you want to update it. And one thing that we do is we do it on a flat fee so that after we're done, the clients can call us as much as they want free of charge. They don't have to worry about getting a bill. They can call as much as they want and say, hey, I know it was 2 years ago. I know that you told me then, but I can't remember what you said I was supposed to do with this new checking account that I just opened. Or we just had another child. Does that change anything? And it's really just that factor of just making sure that if there's anything that sort of the back of your mind makes you think, I wonder if this affects my trust, then it's probably time to put in a call to your attorney. Just ask. And a lot of attorneys are not going to charge just for answering, questions like that. And if you do need to make updates and, things like that, there's fees for that. But it's really just kind of keeping that in mind.
Well, I'm glad you brought that up, Kristie, because it is a very important question. And I love the way Scott answered it, that the trust is only as effective, impacts the assets that are in the trust.
Yeah.
Right.
And so you probably come across time after time where people have gone through the cost, the effort to set up the trust. And then, like you said, life happens, or they never really get those assets in there. And then it's like, it doesn't do anything for you.
I'll bet half of the trust that we didn't write, but somebody did 20 years ago, when they come in, the trust is great. It's a great piece of paper, but they, so much time has passed, they have zero assets that are in the trust. Everything's completely outside of it. And they don't realize that if they passed away, everything's going to go through a probate as if they never did a trust in the first place. And so that's an important piece of it is to keep that in mind. And we reach out to our clients every 2 years after they've done that, just to touch base. And, whether they're going to put a recurring reminder on their phone or something, it's really something that you want to review, because otherwise you kind of waste the point of doing it all if you don't keep things tight.
So as it relates to business owners, and this, as we're having this conversation, I joked with you before that, we have an outline, but it's very loose. And as I was doing that outline, I was trying to differentiate between business owners and individuals. And I'm not sure there's really the need to do that, because really the only difference between the two is that one of the major assets of the business owner is their business. So I don't want to get into a conversation about operating agreements and buy sells and all that kind of stuff. That's prudent business policy and procedure. But am I speaking the right way, that the only difference between a business owner and an individual is that one of the major assets the business owner has is the business itself. So they need to make sure that the business is in the trust, or the business is an estate planning vehicle.
Yeah, that's true. I mean, it is one asset, and sometimes it's a little more complicated to transfer than just deeding property into the name of the trust. But that is one facet of it that does need to be transferred. But especially if you're in a business where you have some partners, it's really important in that case to have some agreements, have some language in your operating agreement or in your shareholder agreement if you're a corporation. What does happen if one of them pass away? It's shocking how many operating agreements we see that have no plan at all for the incapacity or death of one of their partners. And the partners are shocked and horrified to find out that, I may be in business with my partner's spouse or their distant child who has no connection to the business at all. And so you want to have some planning through the business documents of what does happen, and making sure that if that share of a membership interest is owned by that person's trust, then who's in charge of that trust, and ultimately what happens to it? And does the company have some buyback provision so that, sometimes we see business owners where they're all really close, and maybe even sometimes some of the children are involved in the business, and they're fine with that. But in most cases, they're going to want to make sure that the company has a way to separate from the family of that deceased owner just because it doesn't make sense for the business. And you want to have your operating agreements really dovetail with your trust agreements for the members to make sure that there's some consistency there and a plan for what happens if one of them pass away.
I'm going to ask a basic question. It may not even be relevant, but it continues to play in my mind. Earlier, you were saying in the state of. And I know that whenever it comes to individuals, there are certain states differ. What about for a business? Does it vary state by state?
It does.
Okay.
It does.
Okay.
There's a lot of consistency. I mean, big picture items usually are fairly similar, but every state does have different laws on that.
Okay.
You know, Texas, their probate process, air quotes, probate process is very different than Oklahoma. It's really simple. It's you file, in most cases, an affidavit and you're done. And so trusts for estate planning purposes are not as popular in Texas as they are here, just because going through probate's not that big of a deal. But still, you have the issue if you're a business owner in Texas, you still have that issue of, okay, well, but who does receive that membership interest? And so it does vary. And, you know, we have attorneys licensed in 3 or 4 states, but you always want to have someone locally that can kind of weigh in to make sure there's not
a nuance of some kind
that's going to make a difference.
Yeah. So if I'm a business owner and I come to you to initiate some estate planning, the first thing you're going to do is ask to look at my documents, my operating agreement, buy, sells, and all that kind of stuff to nail down what would happen to the business. And then you're going to go from there and maybe amend or suggest some options, things of that nature. Is that right, Scott?
Right. It's really kind of a 2-step process. We're going to transfer, assign your membership interest to your trust, no matter what. We don't care what the operating agreement says. We want to have something in place that at least keeps it out of probate. But then phase 2 of that is, okay, let's look at your operating agreement and let's see what it says, because in most cases, no one's really thought through that process, and we can make some suggestions that benefit not just that client, but their partners. You know, a lot of times their partners then come in and say, okay, let's get ours cleaned up too, and let's update the operating agreement so that we have a consistent process that deals with, those issues. And
I would imagine the old cliche is still true that it's best to do these things when everybody likes each other and not on the back end. And I can imagine there's, when you get into the concept of the ownership interest transferring to a spouse, and you talk about, who you're really in business with, it is a business. It's not personal. It's a business decision that it's not best for me to be. I mean, that's why in our operating agreements that if something happens to me, my wife doesn't come in she can't as a non-CPA, but she doesn't come in as an owner of the firm because she doesn't have the background, she doesn't have the wisdom, the knowledge, or any of that kind of thing. So I would imagine there's certain emotional hurdles that you have to clear as well when these things are not in place.
Well, and a lot of times the spouse doesn't want to come in. I mean, that's the last thing that they would want to do. They want to get the value of what their spouse, put into that business and move on to grieving and, carrying on their life, and don't want to be sucked into some business that they, were only tangentially involved with in the first place. And so it is really critical that the operating agreements lay out. And what is most common is some sort of buyout process. And sometimes it's, the company buys life insurance that just pays for, buying out that interest. Sometimes it can be paid out over long periods of time. Sometimes it's set up where whatever the deceased spouse would have received in distributions for 5 years or 10 years, they continue to receive that, but the equity is out. And so there's a lot of options there. It's just good to have something though.
Right.
Yeah. And I'll say the other kind of thing to think about is not necessarily when you have other owners, but when you have children that are becoming more involved with the company. And we see that a lot. And sometimes that's a good thing or a bad thing. But we've had several companies where, they've got 3 or 4 kids and they're all doing various things, but one of them has been active in the business. One in particular, it's that they have a sod farm that the son is really sharp and has been involved with the company for 10 or 15 years and has really helped dad grow this thing. And it's a really thriving company. And everybody gets along, but it's complicated. If something happens to dad, he's, obviously is going to want some portion of that to go to the son that's in the business. He's going to want him to continue to run it and be involved. But how do you make that fair for the spouse and for the other children? And so that's where, a trust gives you a lot of flexibility to plan for a lot of different contingencies to make sure that, the fairness happens, that there's no uncertainty or no gaps that can create conflict where a family that otherwise gets along now ends up in court and spending half the inheritance on attorney fees.
Yeah.
But yeah, that succession planning internally is a big aspect of the estate planning too.
Right. I've got so many questions going through my mind, and I need to make sure we stay on topic. But I do want to make a point that where your world and my world collide in this area is that when you are putting, we talked about the threshold for a taxable estate and the impact of estate taxes. What we didn't talk about is that when you are putting these items into irrevocable trust, there's a gift that takes place.
Right.
And that needs to be reported if it's over $15,000, $16,000. And that has its own nuance to the calculation. But if you're over the gift threshold of that amount per year, there's a gift tax return.
Are we coding out?
Slightly.
He's getting close.
I'm getting close.
Yeah.
I'm almost hitting the red line
I'm
there.
starting to float.
I just want to make sure that anyone listening knows that there are tax ramifications. And that's why it's really important when the estate planning attorney and the CPA have good relationships and they work together for the client. That's the most important element of what I'm trying to express there, is that our worlds do collide, and it's best when those two professionals are working together.
I don't know how you can have, if you have a family so you're right. So the big, beautiful bill, not too long ago made the taxable estate exemption amount, again, air quotes, permanent, more permanent than it has been in decades, but to the extent anything's permanent in Washington, D.C., to take it for what it is. But it's $15-ish million per spouse, so $30 million together. Again, I wish that I fell into that category, but most people don't. But
what if ChatGPT says it does?
Well, then that's different because
then it's real.
If ChatGPT says it and Claude says it, then you can run with it. But common misconception is you hear this 17, 18, 19,000 annual gift exemption, and people think, oh, that's all that I can give. Well, that's only if you are in that amount that's over that $30 million. Otherwise, you can gift as much as you want, and there's no tax consequences of it. If you are, all that does, and correct me if I'm wrong because you guys are the tax wizards, but all it does is that just reduces that exemption amount that you have in the future. And so for most people, it's not even a big issue. But if it is an issue, you really cannot have a really solid plan unless your attorney and your CPA are working closely together.
Right. And I'm going to get close to that threshold again, but just to clarify, there's a difference between the ability to give and the need to report. Right. So you are correct. You could gift all you want, but if you exceed a threshold on an annual basis, there's the need to report it. And really, you mentioned the exemption. That's what you're talking about. It just reduces the amount, if you're married, 30 million that you can gift. So you're just reporting that, and there is a difference. So
okay, we did it. We got a little.
I like how you simplified it by going. You just. I love how you simplified that.
So as we wrap up, I had a list of questions, and it's interesting because I'm looking at this. I know we've done well because we've covered these things. I just want to hit these, and you can say, "Yep, we talked about that." So myth, fact, or it depends is what we're playing here. Estate planning is only for wealthy people. Period.
That's a myth.
Okay.
That's a myth.
All right. Once your will is done, you're finished forever.
That is a myth.
A trust solves every problem.
That, again, is a myth.
My spouse automatically has authority over my business.
That is a myth. That is not true.
Estate planning can wait until retirement.
Yeah, that's a myth.
And finally, the more complex the financial situation, the more complex the estate plan.
That could be true. We'll end with a depends.
Okay.
I figured All right.
Well
I think
done.
we did pretty good.
Yeah.
We covered everything. So a couple last questions, Scott, just to kind of wrap it up. What are the warning signs that says it's time to call an estate planning attorney for an individual?
When your wife says, if I have to tell you again to call the attorney, then then you're in trouble.
Okay.
It's funny this time of the year. So we're June. This ends up being kind of our busier time of the year for estate planning. And it took me a few years to realize why. And the reason was because it's when everybody starts to go on vacations.
Oh, they had the conversations.
Having that date when they're going to get on the airplane is that date is what can get it done. And usually it's the husband calling about 2 weeks before and says, I'm so sorry. My wife's going to kill me. She said, we got to get this done before we go. Can we get it done? And of course, we say, well, hurry up and get in here and we'll get it done. But that is one factor that helps people kind of get over that hurdle of just pushing it off.
So drive this home. If there's only one thing that a listener should do to move this process forward after listening to this, what, besides calling you, which we're going to talk about in a minute, if they're in the state of Oklahoma, what is that one thing?
I would say get over the perception that you have to have full, complete financial statement, or you have to have all the decisions made, or you have to have all the conversations, with the spouse that are difficult figured out, and push off all the things that can pop up as kind of a hurdle to get it done, and just make the call, go in. Most attorneys don't charge for the first meeting, and just get in there and get the ball rolling. And usually that's the biggest part. Once you do, it usually goes pretty smoothly and you can get it done. And it's for your family. I always tell people that the best gift that you can give your children and your family is a good estate plan.
Right.
It's not the assets. It's just at a time when everyone's grieving and it's not a good situation, to at least have that piece of it that goes smoothly is critical.
And I would say, if you're one of those individuals that says, I don't know who to call, ask your friends. I think this is an area, your profession, your industry, our industry is so important to get a warm referral from someone who's had a good experience, someone that took care of them and would do the same for you. So, Scott, if someone wanted to get in touch with you, what's the best way to do that?
HeltonLawFirm.com is the easiest way. We have a really good intake system that they can find our number and call. Just schedule a meeting. It's really low key. You don't have to fill out any forms. You don't have to go and gather any information. Just show up and have a cup of coffee and we'll talk.
I love that.
And your situation's a little different than ours in that you mentioned licensing and you can practice in the states where you are licensed. I would imagine, I don't want to commit you, but if someone is in another state and they're listening and they could call and say, hey, I heard you on the podcast. I just don't know what to do. You would have someone that would give them some direction.
We would be happy to help. Yeah, we primarily practice in Oklahoma, Arkansas, and Texas for the most part, but we have good relationships with attorneys. Other places we have avenues to kind of sift through to the real estate planning attorneys. So we're always happy to help.
Yeah. It goes back to your second why, to help people.
That's right.
Love it.
Just put them in the right spot.
Yeah,
So
love it.
Scott, thank you so much. Great information. I think it's time now. It's time for
Would You Rather?
So we've been trying to make this a little bit more interesting.
Yeah. Sarah's pretty good at
not
this.
just doing this for the individual, but the individual in the area that they practice.
Yeah.
So, Scott, would you rather?
All right,
Kristie.
Scott, you ready? Would you rather have a perfectly drafted estate plan that nobody can find, or have a messy estate plan that's sitting in plain sight on the kitchen table?
They're probably better off with the one that they can't find than the one that's messy.
Okay. All right.
Good answer.
Would you rather leave the entire business to your most responsible child, or leave it to your least responsible child and hope they figure it out?
Well,
it depends.
I love all of my children equally, but I think I'd take my chance with one of them.
Okay. Would you rather spend one afternoon organizing all your important docs, or have your family spend 6 months trying to find them?
Yeah, I feel like that's my obligation to take care of that.
Would you rather be known as the client who asks too many questions, or be known as the client who never asks questions and Jess signs everything.
It's going to be so much better. Ask a lot of questions. If you know what you have, it's going to be so much better.
Would you rather leave your family a clear roadmap of exactly what to do, or leave them a treasure hunt with clues that are hidden throughout your office?
I don't think that they would appreciate the treasure hunt as much
fair.
As they should.
And last question.
This one's a tricky one.
It is. Would you rather have your CPA write your estate plan, or have your estate planning attorney prepare your tax return?
I would much rather have Jeff write my estate plan than try to do the taxes.
Let's get into the conversation about practicing law, shall we? Well, Scott, thanks for being a good sport with those.
Thank you for having me. It was a pleasure.
Yeah, a lot of good information there. And if you have any questions about anything that we covered, again, Helton Law Firm, look them up, call them, ask them some questions, or you could email us at podcast@cckcpa.com. If you have any questions at all, if you have any comments about the topic or our presentation style, or we still need to work on getting these emails in. We're just not getting the interaction, are we, Kristie?
Oh, yeah. But Clarence and I have a plan.
Okay. So
we do.
Be on the lookout for that. But it's podcast@cckcpa.com. Like us, comment, share us with your friends, and invite, just like church, invite one friend to listen to this podcast and see if it helps them. We would love that. Again, we want to special thanks, CCK, for the opportunity and platform to do this, to try something different in our industry and have fun doing it. KP, extra thanks for sitting in for Sarah this week.
My pleasure.
Sarah, we are wishing you all the best with the credential you're working on today. To her husband, Robert Mays, for the intro and outro music. Clarence, the man, Fisher with Tulsa Internet Marketing Services. We so appreciate you. And Emily Johansson, she is our amazing EA assistant.
Teammate.
Yeah, she gets us across the finish line.
Extraordinaire.
All the time.
Always.
She does a wonderful job, but thank you to her as well. And again, thanks for listening. And we hope you join us next time when these two CPAs, but you're not
because
a CPA.
I am not. Thank
when
you for
the normal
not
two
including
CPAs get
normal?
on the mic. Yeah.
Would you call you guys normal?
Yeah. We get on the mic to have a chat, and you get to find out who's on the mic.
The information provided on this podcast is for general informational and educational purposes only and does not constitute accounting, tax, legal, or financial advice. While we strive to provide accurate and up-to-date information, laws and regulations change and individual circumstances vary. Always consult with a qualified CPA or professional advisor before making any financial or business decisions. The views expressed by the hosts and guests are their own and do not necessarily reflect the opinions of any organizations they are affiliated with. Listening to this podcast does not create a client-accountant relationship. By listening to this podcast, you acknowledge and agree to those terms. And that's a wrap for this episode of Two CPAs in the Mic. If you found today's episode helpful, please subscribe, share, and leave us a review. Have questions or ideas for a topic? Reach out. We'd love to hear from you. Email us at podcast@cckcpa.com.